With regard to the dispute concerning the land, council submitted the eviction in question had been lawfully undertaken and that the circumstances surrounding the disputes did not provide a basis for the continued detention of the respondents. He further invoked the constitutional protection of fundamental rights and freedoms. He submitted that Article 19 of the Constitution makes it clear that the rights and fundamental freedom in the Bill of Rights belong to each individual and are not granted by the state. He further referred the court to Articles 20 and 21, which provide inter alia that the Bill of Rights applies to all laws and binds all state organs and all persons, and that it is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. Consequently, he urged the court to invoke its constitutional mandate to uphold and enforce the respondents' rights and fundamental freedoms and to decline the prosecution's request for their continued detention for 30 days. In addition, Counsel Katunga Mbuvi submitted that there was a violation of the suspect's rights as they were brought to court 36 hours later, and their continued detention will perpetuate an illegality. He further submitted shall be held at Kilimani Police Station. First. Yes. Second at Kilelesho. Yes. Mr. Mbuvi, 25th. Okay, so constitutional rights as provided under Article 49(1)h of the Constitution, while accepting that the text of Article 49(1)f of the Constitution may in certain circumstances and context comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state application to have him so held. The applicable test is whether the applicant has advanced and proved compelling reasons. The prosecution submitted the seriousness of the offense, interference with investigations and witnesses, and the safety of the respondents and public order. I'll begin with the seriousness of the offense. It cannot be gainsaid that the offenses in respect of which the respondents are being investigated are grave and weighty. The seriousness and gravity of an offense, particularly when considered in light of the sentence likely to follow upon conviction, has been held in numerous decisions to be a relevant consideration in determining whether to grant or decline bail. However, the seriousness of the offense standing alone does not necessarily constitute a compelling reason for the denial of bail. Interference with witnesses and investigations. The prosecution alleges likelihood of interference with prosecution witnesses and the investigations. It has been held by a number of authorities that is the most potent ground, and if proved, the prosecution's allegation of likelihood of interference with prosecution witnesses as such amounts to an affront to the administration of justice, thus is a justifiable reason to limit the right to liberty. In the case of Jackton, Mayende, and 3 others, the court held that, and I will quote, "In all civilized systems of courts, interference with witnesses is a highly potent ground on which the accused may be refused bail. It is a reasonable and justifiable limitation of right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. A cardinal tenet in criminal justice, social justice, and the rule of law envisioned by the people of Kenya in the preamble to the Constitution of Kenya 2010. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying a witness, either not to give evidence or to give skewed evidence, amounts to interference with witnesses, an impediment to or perversion of the course of justice. And if it is so found, it is a justifiable reason to limit the right to liberty of the accused. End of quote. In the case of Republic versus Dwight Sagare and 4 others, the court held that, and I'll quote, for the prosecution to succeed in persuading the court on this criteria, it must place material before the court which demonstrates actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect incriminating communication between the accused and witnesses, close familial relationship between the accused and witnesses, among others. End of quote. It is common ground that the first and second respondents are mother and son respectively. It is also noted that the first respondent is the former wife of the deceased husband. The court further notes that there was an existing land dispute, the subject of Machakos ELC, case number E111 of 2025, in which the deceased was named as a third respondent. According to the investigating officer, the deceased had previously reported an incident which allegedly occurred on 7th of July 2026 along Gong Road near Junction Mall. It was alleged that while driving along the said road, 2 men riding on a motorcycle approached her and attempted to shoot her. The deceased is said to have managed to escape from the scene and consequently reported the incident at the police station, that is Kilimani Police Station, via OB number 63/07/07/2026. The investigating officer further informed the court that in the said report, the deceased allegedly identified the second respondent as the pillion passenger on the motorcycle. This allegation is, however, yet to be tested through evidentiary process and must at this stage be treated as an allegation forming part of the material placed before the court in support of the application for continued determination. The foregoing circumstances are relevant to the court's assessment of the alleged gravity of the matter, and in particular, the prosecution's contention that the respondent may pose a risk to witness or otherwise interference with the course of justice if released. The existence of a prior report allegedly implicating the second respondent, when considered together with the existing relationship between the parties and the history of the land dispute, is a matter which the court is entitled to take into account in determining whether threshold of compelling reasons has been met. Nevertheless, the court must guard against making definitive findings on disputed facts at this stage. The question before the court is not whether the respondents are guilty of the offenses under investigations, but whether the material before it discloses compelling reasons sufficient to justify the exceptional step of depriving them of their liberty for the period being sought by the prosecution. Number 3, safety of the respondents and public order. On this limb, the deponent averred that the murder had generated widespread public interest and significant public outrage due to the circumstances under which it was committed and the profile of the deceased, and that the identities of the respondents have become known to members of the public and to the deceased family. Consequently, there exists a genuine apprehension that if released before investigations are concluded, the respondents may be exposed to retaliation, mob justice, or other threats to their safety, and their continued detention is therefore necessary to not only to facilitate investigations, but also to safeguard their own security pending the conclusion of investigations. However, It is the duty of the state to provide safety and security to its citizens. In the case of Republic versus Mujirwa, criminal case number E001 of 2024, where the learned judge held as follows, and I'll quote, "This court's view is that the ground that the security of the accused is threatened by members of the public or family of the deceased should never be encouraged as a ground for denial of bail, unless there is real evidence of actual threat, lest we should inadvertently promote or condone violence, disorder, and usurping of law by individuals or a group of people." End of quote. I find that the arguments that the respondents be detained for their own safety and security without real evidence. In conclusion, and taking into account all the foregoing circumstances when considered cumulatively, are highly relevant to the court's assessment of the prosecution's contention that there exists a real and substantial risk of witness interference. The sequence of events, including the prior report of an attempted attack, the subsequent reports of threats to life, and the eventual shooting of the deceased on 29th of July 2026, provides a factual matrix that cannot be ignored at this interlocutory stage. In the court's view, this pattern of alleged escalation is indicative of a serious risk not only to the integrity of the investigation, but also to the safety of the potential witnesses. In the circumstances, and taking into account the totality of the material placed before the court, there is sufficient basis to conclude that compelling reasons have been demonstrated to justify the continued detention of the respondents. This is necessary to prevent actual or perceived interference with witnesses and ensure that ongoing investigations are concluded without obstruction until their completion. Therefore, the upshot is that I hereby direct that the first and second respondents shall be remanded in custody at Kilimani Police Station and Kileleshwa Police Station respectively for a period of 21 days from today to allow the conclusion of the investigations. In Obita, the court takes this opportunity to express its sincere appreciation to all the learned counsel appearing in this matter for their diligence, erudite and well-researched submissions. Those are orders of the court.
Much obliged. Much obliged. Your right, you can.